In re S.L.M. And whenever you're ready.
Thank you, Your Honor. May it please the court. Attorney Irewolf for the father, D'Angelo Dent. Now, the facts of this case is a little bit different. In this case, before the magistrate, after the child was found abused, fed, and neglected, case proceeded with regular hearings. Father filed a motion for legal custody. We had a hearing before the magistrate. The magistrate granted father legal custody. The trial judge affirmed the decision upon objections. At that time, mother's counsel was just recently appointed. After the judge had issued her final judgment after objections, mother's attorney says, I didn't get notice of the final ruling. I would like a motion for reconsideration. I'd like a chance to get the transcripts and go through it and see if I can file any, a new objection to whatever the magistrate did. And the judge agreed. The judge granted the motion for reconsideration. First of all, she didn't grant it as a motion for reconsideration. She said, I'm going to construe it as a 60B. And on that basis, I'm going to give her a chance to file new objections. Now, I have, again, filed that issue before this court. First thing I want to argue, Your Honor, is there is no such thing as a motion for reconsideration from a final judgment. This court has said that ad nauseum, repeatedly. I know a lot of my practitioners and colleagues, we don't get it all the time, like, oh, we'll just ask the court, can we try again after the final ruling? This court has said again and again and again, you cannot do that. If there's a final judgment, you can do it 60B if you ask for it properly, or you have to appeal. And for mom's claim that her attorney didn't get proper service, this court has already held, that is an appellate issue. And I cite cases from this court that says if you're claiming defective service, you can raise that. And in fact, the judge says, I don't see there was defective service because it looks like your name was on the certificate of service, but in any case, I'm going to grant you a 60B. Now, as I was saying in the other case, mom didn't ask for a 60B. She didn't list what grounds she wanted a 60B. She didn't list a meritorious defense for a 60B. She didn't submit it with an affidavit for a 60B. So basically, none of the basis for the court to grant a 60B exists in this case. And really, it's a final judgment. She should have appealed. And because she didn't, the trial court cannot just say, the fact that mom is claiming, her attorney just got appointed and didn't have an opportunity to file objections, I'm going to grant a 60B. That's not proper under my understanding of this court's jurisprudence. So, unless there's other questions, I'd ask the court to reverse the trial court's ruling.
Since you have time,
Yes.
This is, I think, more procedural than anything legal. In reading your brief, I noticed you said that there was, the magistrate had a hearing, and I know mom was pro se, but at some point, mom filed objections pro se. When was that, and how was that?
Right after the hearing, without the decision of the magistrate, because he was taking it under advisement, she filed her own pro se objection. Basically, I objected to the decision, even though we didn't have a decision at that time. So, but she didn't support it with an affidavit. There was no transcript requested, no precipice. She didn't follow up with it. She just said, I object to the magistrate's decision because I anticipate I'm going to lose. And that it was more of a prospective objection than anything else.
Okay.
If I could say that.
All right.
All right? All right?
Thank you.
Thank you, Your Honor.
All right, again, we'll take